Please join me in welcoming Professor Scott Heerman.
Well, thank you, Brad, for that incredibly kind, generous introduction. Thank you all for your attendance today. I am delighted to be back in what is a sort of intellectual homecoming. I discovered in 2005 some documents that we'll be seeing today that were the germ of the book that is now for sale. I'll underline that. And it's so important for me to be doing this intellectually, not just because it allows me to reconnect with the sources that sparked all of these questions, see some of the reference librarians and staff members, old and new, who made this project possible, but to be back amongst the intellectual community, all of you, that allowed me to think and sort of germinate and test ideas out. So really, sincerely, if the seed was planted of this book a long time ago down on the second floor, I'm delighted to show what has germinated all of that time. So I want to begin with a story, one I discovered here some time ago, down in 2 West. And it's a story that begins in 1848, when an African-American man named Wade was kidnapped out of Cairo, Illinois, there we go, and taken across the Mississippi River into Cape Girardeau, Missouri. Now, Cairo, as we can see from this map, is nestled all the way at the southern tip of the state. With Missouri on one side and Kentucky on the other side, it was trapped between slave country. And countless people, like Wade, were carried back into bondage. Cairo had an important part in the shipping economy, as we can see from these vessels depicted on the river, and it connected southern Illinois into the greater Mississippi River Delta. We see Memphis here in red. Yeah. To cotton country, where African Americans enslaved labored in a form of global commodity production. And so the distance between southern Illinois and the Deep South was not so far, as Wade and countless other African Americans found out. These kidnappings, in fact, were not all that strange. As the governor of Illinois wrote in 1849, kidnapping has been carried to a disgraceful extent in the state. Perhaps it's for that reason that the county courthouse, the county clerk in southern Illinois in Alexander County indicted 3 men for kidnapping Wade. But because the 3 men had left the state and went to Missouri, the governor of Illinois had to formally request their extradition from the governor of Missouri. This is a pretty typical thing that happens. But what might seem like a straightforward case, in fact, turned into a 3-year-long, incredibly acrimonious debate over the nature of slavery and freedom in the United States. The first extradition request was flatly denied by Governor Austin King of Missouri. He said that it is asserted by some citizens of my state that the said man Wade is a slave, and as a result, he must withhold a warrant for these 3 people's arrest. He was suggesting that Wade was a runaway slave from Missouri and was simply being returned. However, he said, if you could provide me with sufficient evidence that this man was kidnapped, I would go ahead and extradite the 3 men. This response shocked Governor French of Illinois. He reminded the governor of Missouri that a federal law required him to extradite the 3 men. This was not something on which he had discretion. And then he went to offer what he said was the most unquestionable evidence that the said man Wade is a slave. He went on to explain that Wade was born in this state since the Ordinance of 1787 was made applicable to the Northwest Territory. As a result, Wade is what is normally denominated in the state as a French Negro. He continued to explain, no claim can be set up to the services of this person as a slave, and to shield these 3 people from extradition would allow them to reduce free men to bondage. But this plea fell on deaf ears, and the governor of Missouri shot back, saying, the 3 indicted men only aided Wade's owner in the exercise of a clear constitutional right to seize and repossess his slave. No state has the power to make it a felony to do so. It is a positive and unqualified constitutional right. And the case was dropped. So in some ways, this is a very typical story, right? It's the 1850s. We have the governor of a slave state and the governor of a free state deadlocked with each other over the nature of slavery and freedom in the Union as we run ever forward to that great sectional conflict when slaveholders would rise up in rebellion against the federal Union and create the Confederate States of America. But as we dig deeper into this case, it in fact confounds a lot of that typical narrative. This is not an instance of what we normally think of slaves coming from the South into the North, someone like Dred Scott. This is not an instance of runaway slaves trying to claim their freedom in the North, someone like Frederick Douglass. Nor is this a case of a free African American being kidnapped into the Deep South, someone like Solomon Northup. In fact, this is none of these three things. This is a dispute over the question, is Wade a slave at all? And by asking those questions, profound issues of state police powers, federal jurisdiction, and the role of slavery and freedom in the United States bubbled up to the surface. In short, we need to answer the question that the two governors were deadlocked over. Is Wade a slave? If so, by what terms? And to do that, we need to dive into figuring out what a French Negro is. We need to look into the communities where people like Wade lived in order to unpack and really rethink a lot of what we know about the coming of the Civil War, the politics of slavery and freedom, and the nature of freedom national, the nature of emancipation in the United States. And that is what my book does, The Alchemy of Slavery. In a lot of ways, what my book tries to do is invert the traditional trajectory of the history of slavery and freedom in the United States. Very typically, we narrate the history of slavery as moving from the Atlantic seaboard into the heart of the continent, that a great transatlantic slave trade shipped 12.5 million African captives to the New World. Some of them landed in Virginia, South Carolina, and Georgia. And then in time, the plantation complex metastasized across the Deep South, bringing African Americans to Memphis, where people like Wade would eventually be kidnapped and reduced into slavery. That is to say, we narrate the history of slavery in the United States as moving from east to west. But just as Wade's story confounds the sort of direction of movement, so does my book. I begin the history of slavery in the heart of North America and trace its connections out to the wider nation. Because to tell the other story presumes that slavery was a colonial imposition on North America, that slavery was something European colonizers brought with them. Instead, slavery, as I show, is indigenous to North America. Native nations enslaved people for centuries before and centuries after European contact. As a result, we need to understand that when European colonizers came to North America, they encountered forms of slavery that already existed, and they adapted. And what I argue in the book is adaptability is one of the hallmarks of enslavement that we have not really grappled with in our larger imagination and in our larger scholarly literature. In fact, I go so far as to argue in the book we need to set aside the phrase, the institution of slavery. Now, the institution of slavery is one of, if not the most ubiquitous phrases in our histories. But what it suggests is that slavery was a single thing, functioned for one purpose, according to a single logic, to serve a single set of ends. Instead, I show that enslavement is a diverse and adaptable and coercive power relationship that enveloped a wide array of people. In short, it's a process of alchemy, whereby indigenous captives were turned into slaves. Slaves, both African and indigenous, were in time turned into indentured servants, lifelong uncompensated. Those people could turn themselves into freed people, who in turn could be kidnapped and returned back to bondage as captives. And it's this constant reinvention, constant adaptation, that I think argues, that helps us imagine the history of slavery and freedom in radically new ways. So if the first point that I want to unpack today is to set aside the notion that slavery is an institution, the second thing that follows from that is slavery could not be abolished at a single moment, right? We can abolish institutions quickly, right? We could abolish the Newbery. We should not, right? But we could, right? We could pass a law saying this thing can no longer exist and we all go home, right? This should not happen, but it's possible. So if slavery was an institution, it could be something that could be abolished in a moment, at an instant. If slavery is an adaptive and innovative power relationship, then the story of emancipation doesn't come at any single moment. Instead, we have to think about abolition as a process. And so when we ask, when did Illinois become a free state? We can't pinpoint a date. It was part of a long, unfolding set of freedom practices, sustained at the local level. In short, what I want to show today is slavery was not an institution and abolition was not a movement. And in so doing, we can rethink and perhaps move past a lot of the most comfortable formulations we have about the sectional conflict, about the dispute over slavery, and about the nature of emancipation in the United States. And to do that, we need to know more about who the French Negroes are. So I need you to come back with me, back further, back to the beginning of the 18th century. And I need you to think of slavery beyond black and white. So as I mentioned, when European colonizers, in this case the French and agents of the French Empire, came to Illinois in the 1720s and 1730s, they brought slavery with them. They brought enslaved Africans with them. But what they also discovered is there was an indigenous form of enslavement that long predated their arrival. And these two forms of enslavement worked in radically different ways. Indigenous slavery was really not primarily about labor. Indigenous slavery was a way to organize power, was a way to forge alliances, was a way to create relationships amongst the many nations of this continent. And so the Illinois Indians, who were incredibly powerful at the beginning of the 18th century, would travel into the Trans-Mississippi West, kidnap and raid Plains Apaches, bring them back to Illinois, and then trade them, in some cases as far east as Iroquois country, modern-day New York. And in so doing, they would become power brokers. They would control the trade and movement of people and goods, and they would forge connections and alliances between all of these different people. Eventually, the French became one of those foreign nations that they needed to forge alliances with. And so they traded enslaved indigenous captives into French colonial society. The French, however, thought of slavery in radically different ways I think that might be more familiar to us. For them, slavery was a legally sanctioned system of chattel bondage where people of African descent would labor on a system of commodity production, be rice or indigo, or in the case of Illinois, grain, in order to enrich merchants in a distant country. In short, we have two different systems of enslavement, one racialized and plantation-based, one more political and alliance-based. But rather than telling an institutional story of slavery and sort of trying to find the overlaps, what I argue is we need to tell an entangled history of enslavement. Because what we see very quickly is these two different structures of enslavement broke down into a more localized system. We can just imagine how an indigenous captive and an African captive, both enslaved in Illinois, both working the fields of Illinois, would in time forge common relationships with each other. And we have proof of those relationships in a lot of different ways. Take, for instance, this baptismal registry from the 1740s. I'll translate, don't worry. This is a Catholic baptismal registry, a transcription of it. Shout out to local institutions, just down the street at the Chicago Historical Society. And it's for two children being baptized, the descendant of an esclave nègre, black slave, infidèle, he wasn't baptized, and a sauvagesse pawnee, an enslaved Indian woman. So at the level of family formation, we see enslaved people of diverse origins intermarrying, having children, and baptizing them in the Catholic Church. This is not two institutions of slavery conflicting with each other. The entanglement is there, and it's very personal. Or we can imagine what daily life in these tiny nucleated villages would look like, right? Indigenous and African-descended slaves lived in this tiny town, this lovely map of Kaskaskia, which again I discovered on the 4th floor a few years ago. Language, religion, culture, all sorts of things would begin to break down as these diverse people cohabited in this tiny, tiny space. In short, this is what the alchemy of slavery looked like, turning different ideas of enslavement into one localized system. And this matters for our story for a variety of reasons, not the least of which is over the end of the 18th century, a variety of different empires claimed the Illinois country. And they all wanted the same thing from it. They wanted access to its fertile fields. They wanted to grow grain and ship it to the Caribbean, or in the case of the French, to Canada. And to do that, they used slave labor. And so, as the Illinois Indians and the French and the British and the Spanish and the Virginians and the Americans all came to the region, what we see is the alchemy of slavery happening each time. Each different empire has its own ideas of how enslavement should work, has its own slave laws. And each different set of settlers would have to accommodate and adapt and innovate to what was there on the ground. I mean, just imagine when the British claimed the region and trafficked enslaved people there from Jamaica, those slaves would have been Anglophone. They would have been Protestant, not Catholic. But once again, the differences would have broken down. So this matters to the sectional story for a variety of reasons, not the least of which is when the Americans showed up, the alchemy of slavery was incredibly useful to slaveholders. Because as I think many people in this room know, one of the first things the United States did was make Illinois nominally free soil. In categorical terms, they declared there shall neither be slavery nor involuntary servitude in the said territory. About as straightforward of an abolition law as you can imagine. But just as slavery did not work according to the dictates of any one group before, it didn't happen this time either. The territorial governor of Illinois said he thought it proper to explain the article respecting slaves as a prohibition to any future introduction of them. It would not extend to the liberation of those the people were already possessed of. Right? In short, he would exempt all of the enslaved people in Illinois from the promise of emancipation. And this interpretation of the law finally won sanction in the state's first constitution, ratified in 1818, which said neither slavery nor involuntary servitude shall hereafter be introduced into the state. And by saying that, they exempted all of the enslaved people in Illinois in 1818 from the promise of emancipation. These were the French Negroes. These were people supposedly descended from the time that the French claimed the region, who would be exempted from emancipation and held in slavery. But one thing I want to stress is this is not a story of slavery persisting despite the law. This is a story of slavery adapting to new laws and innovating in response to new legal demands. Because as I hope is abundantly clear, the French Negroes were not all Francophone and they were not all of African descent. They were British, they were Spanish, they were indigenous. The French Negroes is an invented legal and political category that responds to US law. And as a result, the French Negroes were not kept in a sort of criminal space. They were not trapped in basements. They were not locked in closets. This was a public system of slavery that was legal because of the ways in which the alchemy of slavery worked. And so I have baptismal registries like these from Southern Illinois, dated 1838, for an infant girl who is clearly called a slave, Cynthia Ann Slave. And if we keep reading, we can see who she is a slave of, Judge Pope. The local judge in Southern Illinois baptized this owned this enslaved woman's mother, and this child was baptized in 1838. So slavery in Southern Illinois was public. It was noted in important cultural institutions like the Catholic Church and in the newspaper. And the judges didn't feel any particular legal consequence because there were none, because the alchemy of slavery worked so effectively. So that is almost all of who the French Negroes are. There's one other group of people that are lumped in here. Because if you ban the further introduction of slaves into the state, what do you do when masters from Kentucky or Missouri or Tennessee arrive in Southern Illinois with their slaves? Now, one answer is you could free them, but that's not the answer the officials in Southern Illinois chose. What they said is you had 60 days to turn your slave into a servant. And if you don't, you have another 30 days to leave the jurisdiction without forfeiting title to them. The theory being by signing a servitude contract, this is voluntary servitude. But slaves have no volition at law. They have no will as recognized by the law. So this is a sort of legal dodge that I hope doesn't make much sense to us. but it's the ways in which enslavement could adapt to target new people in response to legal demands. And so we have hundreds of indentures. Some of them look just like this. An indenture for a Negro woman in the Illinois Territory for 99 years without pay. All of these people were exempted from emancipation by terms of the Illinois law and terms of the Illinois state constitution. These were the French Negroes. This is who Wade might have been. So to briefly sum up, what is the state of slavery in southern Illinois in the 1820s? If we look at Randolph County, which is in the modern-day suburbs of St. Louis, the enslaved population we know is roughly 750 people out of a population just shy of 9,000, so about 8.5%, 9%. Census data is, fuzzy, but it's a good guess. On the other side of the state in Gallatin County, bordering modern-day Kentucky, the slave population was a little bit higher, closer to 10, 11%. And the enslaved population was so substantial in these counties that passerbys actually remarked on it. We have accounts saying that the labor force in Gallatin County is mostly Negro. Now, it isn't mostly Negro, it's 10, 11%, right? But it's large enough that people were impressed by it. And if we look at the labor records, the ledgers of the company that was most important in clearing and settling the land, they employed 175 slaves and 45 white men. So these pockets of southern Illinois, in demography and a variety of other ways, looked a lot like western Maryland, western North Carolina, upcountry Georgia, societies with slaves on the margins of plantation economies. So if that's who the French Negroes are, and it's explained by this idea of the alchemy of slavery, I want to spend the rest of the time puzzling over a question. How do you make a free society? How do you free any of these people? The law, I think is clear, won't work. Not just because it didn't work. I mean, there were at least 4 different moments in which slavery was theoretically illegal in Illinois, and that you keep making something illegal is a sign that it's still happening. But think about it. How would you write a law that would abolish all of these different forms of enslavement, right? The categorical ban didn't work. You'd have to write a very complicated set of languages that say these people under these terms and those people under those terms, which in turn would allow masters to say, well, my guy's none of that. So the law doesn't apply, right? That there seems to be no way that you could pass a law to abolish slavery, and that's because it's not an institution. What else would be a good option? An anti-slavery society and a newspaper campaign, the likes of things that William Lloyd Garrison ran in Massachusetts. Well, Illinois doesn't have one of those until very, very late in the game. It settled, there's an anti-slavery society takes off in the 1830s. An anti-slavery newspaper shows up in the 1840s. But still, people like Wade are being kidnapped. People like Cynthia Ann are being baptized. So to the degree that there is an anti-slavery society, it's based here in Chicago, and it does very little good to the people in the southern reaches of the state. A third option would be a political campaign. Someone like William Seward in New York or Edward Everett in Massachusetts, who sort of makes a political campaign, raises awareness, makes enslavement unsupportable. Illinois didn't have any of those people. This was a state run by Democrats in those days, the party of Jackson, the party of slaveholders. To the degree that there are anti-slavery politicians in Illinois, I'm sure you can think of a couple, they come onto the scene very, very late in the game. And so all of the standard answers don't really seem to apply here. And so what I realized in the book, and what I want to encourage you all to do, is to set aside the notion is that there's a moment when people became free, and to think of abolition as a long, contested process of struggle and work at the local level. So that, I hope, is a little vague, because I'm going to spend the rest of my time here with an extended case study exploring what the path to freedom would look like and why that might matter for our stories. This is the story of a woman named Nance Cromwell, also called Nance Costley at various points in the record. We don't know much about her early life. We have some guesses, but we know she is brought into the state as a slave sometime in the 18-teens and converted into one of these servants. Because of when she's brought into the state, she's exempted from the abolition laws, and so she counts as one of these French Negroes. We know she lived somewhere in the center parts of the state, and she first enters the record most clearly and most definitively in 1827. when her master fell into debt and had his entire estate auctioned off, including 2 black women as property. Nance was one of them. And so we know, outside of the courthouse in Springfield, Illinois in 1827, Nance was sold at public auction and to a new master by the name of Nathan Cromwell. And we know from the record that in pursuance of the sale, the state official did deliver the said Nance to the said Cromwell, and the said Nance went voluntarily and of her own free will and consent with her new master to his place of residence outside of Springfield. That seems like a strange thing to include, but it'll matter for a moment. Witnesses of the sale, though, describe things going very differently. Jane Cox, this is the mother of the man that had fallen into debt, said she saw this woman Nance confined with chains and that she became very sick, thus confined. After being sold at auction, she overheard the state official ask if Nance would go and live with her new master, and Nance refused and presented she would not. The county official then took her behind the old salt house, and it was only after this that Cromwell took her off. So at a public auction in 1827 outside of Springfield, Nance was chained, was beaten, was sold at public auction, and dragged off to a new residence. Now, if this doesn't seem right to you, it didn't seem right to Nance either. And within a year, she filed a suit for her freedom. She petitioned for a writ of habeas corpus in the local county court and said, "This is a violation of state law. I have been beaten. I have been shackled. I am not a voluntary servant anymore." As she says, "My place of residence was taken against my will and consent." Now, she lost at the state level and faced appeal up to the state Supreme Court. And there, with help from a lawyer, she argued that by terms of both the 1787 Northwest Territory Ordinance and the 1818 state constitution, this should be illegal, right? The state Supreme Court disagreed, and they ruled the fact that she signed a contract meant that she was a voluntary servant, even though she was an enslaved adolescent girl at the time, and the fact that she went to the new place of residence meant that she consented, even though she was beaten and chained and dragged off. And so in 1828, the system of exempting French Negroes faced a test before the state high court, and it passed. And Nance went back to living in servitude for another 11 years. When in the summer of 1839, she exited her servitude contract. The terms of labor had expired. But that summer, she lived in a very precarious condition. She did not have proof of her freedom. She had no manumission paper, no freedom certificate from the local courts. And so her master attempted to sell her again, this time to a new man by the name of David Bailey, who was going to take her out of the state and re-enslave her, the type of thing that happened to Wade. Nance then, having experience doing this, decided to sue a second time. And this case raised another important legal question. Where does the burden of proof for black freedom lie? Before Nance's case, the burden of proof was on all African Americans to prove that they were free. It was presumed at law that they were slaves. And if they wanted their freedom, they had to produce authoritative legal documents, which can be very difficult to get. Nance argued, because we have so many laws making slavery illegal, in fact, the burden of proof should be on the master. She shouldn't have to prove that her servitude was free. Her master should have to prove that she was still a servant or slave. So this is a major legal question, right? This is not an easy thing to argue. And having lost once before, she almost certainly knew that what she needed was a very good lawyer. And she got a stroke of luck because that man, Abraham Lincoln, argued a writ of habeas corpus for her in the Tazewell County Courthouse in the summer of 1840. Lincoln, an able legal mind, to put it mildly, won, which should not shock any of us. And he faced appeal again up to the state Supreme Court. And I'll just stress that you keep taking this to the state Supreme Court makes you think you have a leg to stand on. Right, makes it show just how weak these anti-slavery laws really were, because her masters, both of them, in the mid-19th century, kept going before the High Court in order to keep her in slavery, and the first time they won. So in the summer of 1841, Abraham Lincoln argued before the state Supreme Court in the case of Bailey versus Cromwell that the legal proof of freedom should be on the master, not on the slave. And he won a second time. This was an important legal victory for people like Nance, for people like Wade. And so what should be clear from this is it's difficult to pinpoint when Nance became free. What's the date? Was it 39? Was it 40? Was it 41? Right? There's no real moment. It in fact was a years-long process. And when we understand that litigating the nature of freedom for the French Negroes was a years-long process that consumed senators and local officials in the state and governors, I think it can help us reimagine some of the later freedom struggles that took off during the sectional conflict of the 1850s and 1860s. That in some ways this was a trial for those later debates and that great fiery trial. And as it happens, Lincoln was not the only person that would return to these questions in the state later on. Because in the summer of 1841, this man, Stephen A. Douglas, was a state Supreme Court justice. And so when the two men in 17 years would meet again and debate the nature of slavery and freedom in the Union, it was not their first meeting doing this. In some ways, we can think about this as the first Lincoln-Douglas debate that would shape the later context of the 1858 Senate race. Now that doesn't really work because they were both on the same side. They both wanted Nance freed, so it's more the Lincoln-Douglas conversation. But nevertheless, the fact is that conversation was being had 17 years before their famous meetings. And so the road to Freedom National, the road to the 1860s, ran through the French Negroes, ran through people like Wade, ran through people like Nance. They were part of this larger national coming to terms and reckoning with the role of slavery in the nation and how just exactly would you make a free society. And that point becomes ever clearer when we continue the story and we see what happens to Nance's son. In 1863, Nance's son, William Costley, enlisted in the 29th Volunteers. He fought just outside of Vicksburg after the siege. He fought in northern Tennessee. And as fate would have it, he, along with the rest of the Illinois 29th Volunteers, spent the afternoon of April 9, 1865 at Appomattox Courthouse to witness the formal surrender of Robert E. Lee to Ulysses S. Grant. We do not know what William Costley thought that fateful afternoon as Freedom National was finally made real. He almost certainly knew that his mother's lawyer went on to become the great emancipator. That's not something you forget. He almost certainly knew that the path to Appomattox did not just run through the Civil War and the traditional sectional conflict we're all so used to. It ran through his family as well. And when we appreciate that, and when we include these people in the larger histories of slavery and freedom, we can begin to imagine that great reckoning very differently. And I'll conclude on this point, just one way to show how that is true. And it becomes very clear if we jump forward to today, almost today, to 2007, where in February of 2007, Barack Obama went to the old State House in Springfield to declare his historic campaign for president. And he chose Springfield because it was perfect staging for him. He was and is a master of this, so this shouldn't surprise us. Because standing outside of the old State House, he wanted to evoke the image of the man just down the road and the arc of history that ran between him and this man, Abraham Lincoln, whose statue stands outside of the new State House just down the street in Springfield. To think about that moment where Lincoln could break the shackles that bound millions of African Americans, and the moment that he could perhaps shatter historic race barriers in our electoral politics. Two great moments of triumph happening here in Springfield, the very place where Nance was beaten and shackled and sold. And so it's no accident that at the crescendo of his speech he declared, and that is why in the shadow of the old Capitol, where Lincoln once called on a divided house to stand together where common hopes and common dreams still reside, I stand before you today to announce my candidacy for President of the United States. And the crowd went wild. But what I'm arguing is we have to begin the story one statue over, at the statue of Pierre Menard, also outside of the State House, just a few feet away from Abraham Lincoln. Now, Menard is no longer a household name, but in the 19th century, he was known as the father of the state, and he was an incredibly important political figure. That's how he got a statue to him built. But as you might guess by his name, Pierre Menard was a French settler, and as you might guess by my talk, Pierre Menard owned French Negroes. In the 1840 U.S. federal census, the very time that Nance is suing for her freedom a second time, he's recorded as owning 12 slaves. And so the distance between Menard and Lincoln includes a freedom story, one that I think can help us reimagine that larger freedom story on display there in 2007. And it can help us set aside what is a very common notion about how we think of emancipation. It can help us, set aside images like this. Waiting for the Hour. This famous painting. Oh, no, sorry. This famous painting, you all knew it, you didn't need it up there, it's so famous. This famous painting that depicts that moment, the strike of midnight, January 1st, 1863, when the Emancipation Proclamation would go into effect and millions of enslaved people would be free in an instant, in a moment of midnight jubilee. I think this is how we often think of how freedom played out. It's an incredibly important image. It's no accident that for 8 years it hung on a hallway between the president's private study and the Oval Office when Barack Obama was in the White House. But as my talk and as Nance's history encourages us to think, freedom came not at the stroke of midnight, but as the title of my talk says, round about midnight. As that great jazz chart suggests, it's written in moments of improvisation, of exploration, of ruptures, of new history being made, and of setbacks. There was no moment of midnight jubilee for people like Nance and for people like Wade. And when we include that in the larger history of slavery and emancipation in the United States, I think it helps us come to terms with that great reckoning with slavery in the 1860s and perhaps reckonings of our own that are alive today. Thank you.
Thank you, Scott. Thank you, Scott. We're going to take questions. We'd like to use the microphone while we do so because we're recording today's conversation.
So I'll ask the first question. I'm just curious, in 1840, how did Nance and Lincoln get together? What was the process? Because Nance is a slave of meager resources. Did Lincoln kind of know of the prior court cases and do some research and help find her?
Yeah, so this is a fantastic question. And the mechanism by which enslaved people met their lawyers and the mechanism by which they accrued legal knowledge is incredibly opaque. I wish I could give you a firm answer. What we can do, though, is imagine if you are this woman and your life depends on how these laws shake out, you're going to know an extraordinary amount about the law, right? People today who are foreign nationals know an extraordinary amount about immigration law, right? Not because they went to law school, but because their lives may depend upon it. Jailhouse lawyers. Jailhouse lawyers. Well, so there are. We might think about it as a jailhouse lawyer, but what I'm suggesting is that this is in the air they breathe. They don't have to go into a particular space. It's simply everywhere. Now, the Nance decision in 1827 was famous. Lincoln would have read to join the state bar. He almost certainly would have known about it, or if not, he would have learned about it very quickly. And Lincoln also filed a number of suits for African Americans who were being sort of detained or harassed by the state's black laws, so he might have had some notoriety for that reason. So I don't exactly know, but what we know is that people with meager resources learn an extraordinary amount about the law very, very quickly when the stakes are so high. Hi.
Thank you. Going back to the beginning with Nance in Illinois, if Nance was freed or became a servant in 1820, would she have appeared in the 1820 census?
Not by name. So there, in the U.S. federal census, no. We don't get official slave schedules until 1850.
But she wasn't technically a slave. They had converted her
Yeah.
from paper to servant.
Yes, I wish in another presentation I have the image of what the census actually looks like. And there are categories for unfree people that you would have seen tick marks there for. So her name wouldn't have appeared, but there would have been a tick mark there for her. There's also an 1825 state census, which you'll have access to down the room, or at least a few years ago I did. And she would appear on things like that as well.
Okay, but not by name.
Not by name. The only chance you get names of this is these servants had to be registered at the courthouses. And so in some courthouses, these registries were created in the first place and then survive, and in other state houses, they don't. And so if you want to trace these down by name, the best bet is to go for these registries of servants and slaves that exist in some counties and not others. But I've never found her servitude contract or a registry of her. Thank you.
Thank you so much for this. I had a question also about the lawsuit. So you had mentioned specifically that Nance herself used the language of consent, that she hadn't consented to this. Could you speak a little bit about how that kind of showed up in the document, like that concept, and in other legal petitions that you've seen around that time? Like how often this concept actually shows up?
Yeah.
And just like maybe just in general about that era, because it's like the moment, about 8 years from now, the American Medical Academy will like institutionalize its first code of ethics. And you see consent as a thing that shows up where physicians suggest at that point that they have the consent of enslaved people when they're operating on them. So how much this word is kind of floating in the air?
It's everywhere. It's absolutely everywhere, not just in Illinois, but in the servitude laws of every single state of the U.S. North. So let me try and unpack this as best as this gets quite technical, so maybe we can talk after. But this is to say that any child who's a slave who's brought into the state, defined as someone under the age of 15, could not consent and therefore just became a registered servant, which is a slightly different category of servant that has its own lawsuits before the state Supreme Court. It's in the book. And so they're very much aware of the notion of consent in the servitude system, right? Because the dodge that they are going for is to say this is voluntary servitude, right? That's the sort of veneer by which they can make this legal. And there's another case in 1828 from another enslaved woman before the state Supreme Court where they sort of say, well, look, this coercion at the point of signing a contract voids its consensual nature, right? If you put a gun to my head and I signed a contract, I can usually get that voided. And the state Supreme Court says no, that in fact coercion at the point of signing a contract and violence in compelling what's called specific performance, where you actually have to do exactly what the contract says, is still all voluntary. I'll point out a dissenter, the one dissenting vote on this, said that this is a logic that insults common sense. So I hope it didn't make sense to people at the time, but this is the alchemy of slavery. The final thing that I will say is that all across the U.S. North, there's servitude systems as well, which function slightly differently. And there in New York, there's an important 1808 ruling that says, look, these lifelong contracts signed by adolescents with guns to their head are not voluntary, right? That New York and Pennsylvania and Connecticut a bit later all sort of rein this in. What's interesting is that when the Illinois State Supreme Court reaches the same questions that were at play in the servitude systems in other parts of the state, they uphold it. So it's a bit of an outlier there, but yes, these judges are forever trying to unpack what consent means and how it might function, and there's not a lot of resolution really until the 1850s.
Okay. I was surprised to see that slavery moved as far north as Springfield, Illinois, and it was a center of many of the trials there. How far north did that type of slavery go in the state of Illinois?
Well, to first remind you that if we remember slavery as indigenous, it was all over the state of Illinois for centuries before it became a state, right? There's nothing really geographically that defines slavery. Enslaved people were used in mining silver mining in Mexico or lead mining in Galena. And so in Galena, there's actually a sizable enslaved population that work the lead mines, because essentially, who else is going into these death traps, right? Unless people are going to be coerced into doing that. John Kinsey sold a slave in 1806 here in Chicago. As late as 1842, an African-American man who was working the North Branch of the Chicago River sort of got into a dispute with his employer. His employer sort of claimed that he was violating one of the state laws, and he was sold at public auction in Chicago in 1842, November of 1842. And so, if slavery is an institution, then it has to be wedded to plantation complexes, which then are dependent upon all sorts of climate and soil, right? Sugar doesn't grow in New York. It does grow in Jamaica, right? This would explain how enslavement worked. If we set aside that idea, then it really shouldn't surprise us that slavery is everywhere, right? It's one incredibly brutal, violent power relationship amongst many.
Stephen Douglas, his Freeport Doctrine. I was curious how you assess that in light of your comment.
Yeah, it's in chapter 6. But right, in some ways, I mean, it's not a plant, I promise. I promise, right? But in some ways, that's you understand exactly the crux of my argument, right? So for those who aren't so steeped in the Lincoln-Douglas debates, right, this is this famous moment in Freeport where Lincoln and Douglas are debating in 1858, and Lincoln is trying to pin Douglas back, pin him against a wall rhetorically, because Douglas's solution for dealing with the sectional conflict was popular sovereignty, right? We're going to put it up for a vote. And if a state wants to vote to be slave or a state wants to vote to be free, so be it, right? A wrench gets thrown in this plan by the terms of the Dred Scott decision, which says slavery is a national institution. It cannot be abolished by any state legislature. It is protected in the Constitution. So Lincoln then says, well, wait a minute. Will you extend popular sovereignty to the point that you violate the Supreme Court, that you violate the Dred Scott decision, right? And this would be akin to, and if Douglas said yes, right, then he would lose support all across the South, right? The Southern planters would never back him if he said he was willing to violate the Dred Scott decision. And so what Douglas then does is come up with what's called the Freeport Doctrine, which says we can pass whatever laws we want, folks. We can have whatever Supreme Court rulings we want, folks. Slavery is a local institution. If it is supported by people on the ground, it will exist. And if there are this sort of set of freedom practices that oppose it on the ground, it will wither and die. And by saying that, he is saying what should be obvious to us. We have the Northwest Territory Ordinance, right? It will have as much force as the state Supreme Court ruling, right? So in many ways, Douglas's Freeport Doctrine illuminates the fact that slavery is always a local, adaptable institution, that the law's ability to control where and when slavery exists is tepid at best, and that in some ways we should think about Illinois more as the land of Douglas than the land of Lincoln, because Douglas was articulating this local history which he lived his entire life. It doesn't alliterate, so I doubt we'll change the state slogan, but.
Scott, thank you. This is for illuminating this really nuanced history of slavery in Illinois. The institution of slavery in the South, one of the key components of that was children born of enslaved peoples are themselves slaves. How did that play out in Illinois?
Yeah, I mean, Cynthia Ann is your answer, right? That children we have infant baptisms. So we have a lot of suggestive evidence that people are born into slavery. They say I was born into slavery or what have you, but that could be a dispute. But I have, as late as 1842, is the last one I have recorded in the baptismal registries of the Catholic parishes of Southern Illinois, people that are infants who are being baptized and being called slaves that look just like Cynthia Ann. So we know into the 1840s, inheritable bondage exists. And in some ways, this is what is at dispute with people like Wade, right? If you say slavery shall not be hereafter introduced into the state, does that mean slavery as an inheritable institution survives and all children exist? Or does a child being born into slavery constitute the hereafter introduction, right? That is in no way clear, right? There's nothing inherent about what the word hereafter would mean to children like Cynthia Ann or to children like Wade. And so in some ways, the dispute over Wade is asking, if you are born of enslaved woman in Illinois in 1820, and you are held as a slave, are you part of the exemption? Are you part of the introduction? And that depends on who's on the ground and who's litigating that and who has the power to enforce that. That depends on the sort of Freeport answer.
I found your characterization of slavery and abolition as a process rather than institutions quite interesting to think through. But that led me to thinking, is not freedom also more a process? And the piece missing for me is, well, and I'm sure you didn't stop thinking about this with the Emancipation Proclamation, but is justice, right? And so I'm just curious if you're thinking about another book, or how you think about where we have not made it to in the last 150 years or however long that is, on what should be a road to justice for people who were enslaved or affected by that.
It's a profound question that I really think about every day, and I encourage everyone in this room to do that as well, right? I mean, that ultimately, because I can't answer that question, I'm glad I'm up here talking about it, because those are the questions we need to think through collectively. I think what I'll say to that is there's a very, very old book that talks about freedom in the 17th century that says, in the wake of emancipation, tyrannies yet more devious may adhere themselves into the human condition, right? That if we understand enslavement as an adaptable power relationship, there's no reason it can't keep adapting, right? There's no reason why we can ever stop looking for the types of local practices that are going to support people living in a condition of civil freedom, right? And what that means is radically different from emancipation, right? And this gets litigated all through the 1850s, 60s, and 70s, and today as well. And I think my answer to that then is if looking at the past tells us that we need these local processes, right, to bring people into that state of freedom, right, to as Lincoln says, live so that the hands may feed the mouth of the bread that they alone have earned, right? The question then is, what are those practices today? And as much as I think my book can go everywhere, 1850s Illinois is not going to tell us exactly the answer for 2019 Chicago. What it will tell us, though, is we have to look for those processes and cultivate them where they are, because that's what worked before, and it might be worth trying again.
Thank you, Scott. That was a terrific ending to a really thoughtful presentation that stirred us all. Thank you.
Thank you. Thank you.